All right, the time is now 7 p.m. I call the March 18, 2026 Village of Suffern Planning Board meeting to order. Please rise for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, thank you. First item on the agenda is sign application for Taqueria America, 21 Lafayette. I don't know if anybody's here for that. We do have a memo from the building inspector. They failed the fire safety inspection. There are multiple outstanding issues that must be corrected, and reports must be submitted before any fire safety certificate can be issued. Otherwise, there's no problem with the sign. We can approve it contingent on them getting all of these things done.
This is him.
Oh, all right. You know what? Armando's. Jump right up. No, you're on.
The microphone.
Yep. Please state your name and address for the record.
Yes. Armando.
Talk in the mic, okay?
Yeah, my name is Armando Arellano.
21 Lafayette Avenue?
21 Lafayette Avenue.
Okay, so we were just discussing, the sign application itself is fine, but there are multiple outstanding issues that you have to correct.
Yes.
And reports that need to be submitted. So we can, if the board elects to, approve the application contingent upon you getting all these other things done so you don't have to come back.
Oh, okay.
Did you meet with Adam Peltz? Not Adam, with Derek Peltz, the fire and safety inspector?
Yes.
And you have things you have to correct? That's what
Okay.
they're talking about.
So if we approve this, it's contingent on you getting all those other things done as well. Does that work?
Yes. Yeah.
It's contingent.
You can approve the sign if it's good.
Okay. Anybody have any questions or comments?
No.
Mr. Halper, any questions or comments?
No, thank you.
Okay, so we will talk to the fire inspector to make sure that you understand everything that needs to happen. Do I have a motion to approve this sign application contingent upon all of the issues being rectified?
Okay.
Do I have a motion from anybody on the board?
I will.
All right, Mr. Van Sickle, do I have a second?
I'll second.
Mr. Halper, all in favor, say aye. Aye. Motion carries. Good luck. We'll have the fire inspector reach out to you.
Okay.
All right?
All right. Thank you.
Thank you.
Armando, before you hang the sign, though, you have to go see them upstairs.
Okay.
Okay?
Okay. Thank you.
Okay.
All right, up next, Dunkin' Donuts sign application at 66 Lafayette Avenue. Is there anybody here for that?
They couldn't be.
They couldn't be here?
It is Dunkin'.
Yeah.
Dunkin' Donuts.
Oh, it's Dunkin', not Dunkin' Donuts. I stand corrected. Okay. Who knew? And there are no issues with it? Anybody have any comments about this sign?
No, it's okay.
Okay, do I have a motion to approve the Dunkin', not Dunkin' Donuts sign?
I'll make that motion.
Mr. Halper, do I have a second?
I'll second it.
Mr. Van Sickle, all in favor say aye. Aye, motion carries. All right, next on the agenda, 158, 160 Wayne Avenue, the multifamily project. It's a revised site plan and a continuation of the public hearing.
Good evening, Mr. Chair, members of the board. As you may recall, my name is Dan Richmond with the law firm Zarin and Steinmetz 81 Main Street, White Plains, New York, on behalf of the applicant. And with me is the project's engineer, Mike Calise, and the project architect and planning consultant, Pete Gato Jr. of Pete Gato and Associates. Your board is, I think, very familiar with this project at this time. I think we've addressed virtually all of your concerns. We did get some comments from your consultant relating to civil, which I think we have mostly addressed. We would hope your board would be in position to issue a negative declaration this evening. I understood from the planning consultant's memo that their primary issue was having DOT sign off on traffic. We provided an email just now to Bonnie that indicates that DOT has indicated that our traffic study is adequate and meets their standards. So we're anxious to move this project forward. I know, and Mike will talk about it more, there's one issue that came up recently, it came up at the last public hearing concerning drainage in the area, which is an existing problem, flooding that affects the entire area. I want to be clear, we are not, it's certainly not impacting that, not exacerbating that. We have a stormwater pollution prevention plan, or we'll be developing one that assures that it meets the requirements, including no increase in peak runoff from the site. It sounds, I mean, again, I don't want to, Mike will discuss this further with you, but I think as your board knows, United States Supreme case law establishes that before you can impose a condition or a requirement on an applicant, there's got to be an essential nexus between the project and its impacts and whatever is being demanded, and then the demand's got to be roughly proportional to that. We read in the most recent memos sort of suggesting that we should take on entire responsibility for what's an existing flood problem. That's, again, not fair, not right, and not legal, because, again, we are not impacting the existing flooding conditions. Again, if anything, we'd be contributing in our own way to improving the situation and certainly not exacerbating it, so that, again, the second step, there's no rough proportionality between any demand, that we take care of the other flooding issue. Mike, I don't know if you want to speak further on the overall project. We're happy to answer any questions your board may have, and we look forward to advancing the project.
Good evening, Mike Calisi, engineer. We reviewed the situation while finalizing our SWIP. The main problem with the flooding in the areas, Wayne Avenue 202 is owned by New York State. The pipes that were installed when they did the original road were, as best I can determine, were designed probably for a 25-year storm event. That's why you have the issue of the flooding in that area. As far as the site goes, we address all the concerns of the site. We will contribute no additional runoff towards the state right away. All right, we've taken the existing conditions and we're releasing our discharge at the same rate as what exists on the site today. The comments we had about the SWIP, they weren't structural comments about the SWIP, they were more that I can remember off of the top of my head. They wanted something about climate change's effect on the SWIP and that nature. But there was no comments on the amount of water, how we were handling the water and so forth. So it's my opinion that, one, we should not create any additional flows down into the flooding. We've handled that as part of our proposed conditions. I brought a copy of, last time the board wanted to see the system we were putting in. If so, I had brought copies of what we were installing. I can give it to you if you like, so you can look at it.
Thank you.
And then we believe that should, wrap up the drainage portion of the job.
Thank you.
Thank you. Thanks.
Thank you.
You're welcome. This is just an overview of the system, as well as details of the system we're proposing. Also, it was brought up by the consultant that we didn't have the soil testing, but it was done in December. I have copies of those results, which I believe were transmitted via email, but I can give a copy to your planning consultant as well.
Anybody have any questions or comments so far? Ms. Franson, do you have any comments?
So our engineers did take a look at the plans, and the applicant had submitted a stormwater pollution prevention plan, which is supposed to document the potential increases in stormwater and how that will be mitigated for their project. And in terms of the memo that the engineers wrote, all of the stormwater pollution prevention plan questions with regard to the analysis, assumptions, et cetera, have not been addressed because I don't believe another submission was made after the first SWIP was prepared.
That's correct. Once again,
Yeah, speak into the microphone because they can't hear.
once again, when you look at the comments aren't talking about the quantity or anything in the water. The amount of water, excuse me.
So, again, this is engineering comments. I'm just trying to see, it talks about outfalls, pre and post development maps, groundwater indicate depth. It gets into some of the assumptions that are built into the analysis to make sure that the drainage is addressed. So bigger picture, I don't think that we're far off. I think we just need to make sure that it's adequately addressed through the analyses and make sure that all the assumptions are correct to make sure that everything is properly designed and scaled. I think the question tonight is where we are, and Mr. Richmond referred to this. He's asking for a negative declaration. For something of this scale, we would normally prepare a written negative declaration. He did provide me now with a email that was prepared by Jason Brenner regarding traffic. We had something from Shahid, who I believe is more the engineer that deals with the improvements themselves. Jason is usually handling the traffic. So it would appear that...
That's with DOT, you mean?
Yes, with
New York
DOT,
State DOT.
correct. So that seems to be done. I can't speak to the drainage. I don't know that we're quite there. And then one of the items that we normally include in our negative declaration, which I expressed to your attorney, is we do like to talk about potential impact to recreation and then address whether or not you're going to ask for a fee to mitigate those potential demands. So I think that's another topic that the board should discuss. But again, I think we're very close. If the board wanted me to, we could draft a negative declaration for the next meeting and hopefully iron out any drainage concerns. And then we'd just like to hear back from the planning board in terms of expectations with regard to recreation.
I just, in response, I appreciate the comments. I think we did talk about the recreational space last time, that we are already providing recreational facilities. Again, the project planner and architect, Pete Gato, could walk you through it again if you would like. But I think you've seen that. I think we adequately provide for the...
Yeah, I think you're interested. But, well, the issue is, you know, the statute says, and Bonnie and I had this discussion, you know, that you would provide a park on site, you know, and this is not just to you, but in general. And if not, you know, is it open to the public? Is it only for folks who live at the residence, et cetera? And is it sufficient, et cetera? So I think what might be a good idea is perhaps have Bonnie look at that as well as part of the neg deck, and I'll recommend to the board maybe if the board, you know, this has been hit before the board live, you know, still hear from the public, but if the board is amenable, is to have Bonnie prepare the neg deck for next time, and if it's appropriate for adoption at that time, you can adopt it. If there's some changes that need to be made, it can be changed. But I think that would be another thing that could be addressed, you know, between now and the next time, in terms of the adequacy. And you obviously would get credit for, in terms of recreation, recreation that you're providing on site for residents in terms of in the building and as well the playground.
Well, I think that's the ultimate question. Are we providing for the project's recreational needs?
Right. And not just necessarily for these units, for their impact, throughout the village in terms of, bringing new residents in and their impact on recreation in the village. So, all right, I think that's something that she can address as part of the neg deck.
Yeah, I mean, again, to be clear, I mean, I think the issue is, are we providing for our residents' recreational needs?
Yeah, I mean, what I would recommend, maybe take a look, we can discuss tomorrow, take a look at the statute. If you want to submit do a brief email or letter submission to myself and Bonnie, and we'll take a look.
Okay. We can include that as part of our next submission.
Yeah, just so we're clear on the applicant's stand, my recollection, and if I'm wrong, please let me know, my recollection was that you felt that the playground equipment was sufficient and therefore there was not a need to provide a fee in lieu of recreation. If that's not accurate, then, because that might have been one of the responses along the way with our comments. If that's not the case, then just let us know.
I think that's the issue. I think it's not just the...
You have to speak into the microphone.
Sorry. I think it's not just the, the playground equipment as people. I think we also have a basketball court and other amenities. And I think the issue is a board can only require a fee if we're not accounting for the recreational needs of our residents. But I'll submit that.
Right, and you can look at the statute, but it doesn't quite say that.
I'm pretty sure the case law, that's where it goes, but we'll do a letter with our next submission. I hear you.
Okay.
And this is a open public hearing. If anybody from the public would like to come up and ask questions or make comments, please feel free to.
Okay, so you want to continue it to the 23rd?
Okay, yeah, so we're going to continue this to 22nd of...
No, I think...
Will the board take the action of directing or asking its consultant to prepare a negative declaration for consideration next time?
Ms. Franson, are we there yet?
So we can draft that. Again, we'll work with the applicant just to make sure that any drainage questions are addressed. Because again, I think traffic is, and drainage was the last piece, and then just resolving this recreation question. Okay. I think other aspects have been addressed.
Yeah, motion to continue to the 22nd.
Right.
Consider draft of the declaration.
Right. Do we have a motion to transfer this to, it would be April 22nd, to continue it in April 22nd and draft a neg deck? Have a motion from anyone?
In consideration of
In
the
consideration of the neg deck. A motion? Mr. Murphy, do we have a second?
Second.
Mr. Halper, all in favor say aye. Aye. Motion carries. We'll see you on the 22nd.
Thank you very much. We look forward to working with your board and getting this done.
Okay.
Thank you, Bonnie.
37 Washington, they're on.
37 Washington is off.
Oh, yeah, they're not here, no, I thought that was better stuff.
Okay. All right, next up is 14 Wayne Avenue, site plan application.
What happened with 37 Washington?
They're not here.
We're going to the village board now.
Nice to meet you. Okay. See you later.
Dun, dun, dun.
We'll chat.
Good evening, Mr. Chairman. Mr. Chairman, our engineer, Paul Gdansky, is expected here at about 7:30. If you have another item that you can deal with at this point.
We actually don't have anything else.
You don't have anything else? All right. Well, let's get started then. So as the board knows, when we were here in January, we had talked about the difficulty that we had with getting any having a back and forth conversation with Ms. Franson. The board at that time had directed Mr. Magrino to set up a CDRC type of hearing, type of meeting, which we had agreed to. That didn't occur for reasons that I think Mr. Magrino is better at explaining than I am, because he had the conversation with the village attorney. In any event, the result of all of that was that we would have that CDRC type of meeting this evening with the full board. I had sent a letter dated March 4, 2026 with additional materials to the board, in which we responded as best we could to the letter from Ms. Franson. Today at 5:01, a little over 2 hours before, we got Ms. Franson's response to my March 4th letter. And I think the best way to characterize all of this is that we're talking past one another, which is exactly why we wanted to have a conversation over a table to discuss these things. And I think what we would like to do is just go through her memo and our responses and see where we are having this disconnect.
I just, before you get started, I just want to make it clear where you are in the process and the board's role here, and maybe you can indicate what, you're back here for. So this is a use that is a special permitted by special permit.
That's correct.
The village board is the board that grants a special permit. So they have applied to the village board for the special permit. As part of that process, the village board refers it out to this board for its comments, mostly on the use issue, but also some site issues if things can get addressed early on, and for secret purposes as well. So this board did issue a negative declaration. The applicant went and did get some variances from the ZBA, and then went back to the village board for further consideration of the special permit. I guess maybe you could clarify why you're back here.
Sure.
At this point, just so that we're procedurally have an idea of what, what's going on at the village board, what's happening
Sure.
here in terms of the process of the application, where it is.
Okay. First off, let me state for the record that we are not expecting any formal action by the board this evening. Okay. This is a conversation that we are having, that we think we need to have with Ms. Franson, and of course board members can interject as they see fit. Many, if not most, of the comments in Ms. Franson's memos have to do with the site plan. They're framed in terms of the special permit, which is appropriate, because the site plan does inform the special permit use. It informs how the use will, in fact, occur. It's for that reason that every time you want a special permit, you have to also get site plan approval, because the two do go hand in hand. This board is the board with the specialized understanding of how site plans work. And we felt that this board had first of all, it had an understanding of what the applicant wanted to do, as evidenced by the negative declaration that you granted. And secondly, because this is, again, many of these questions are site plan issues, we felt that it was important to work this out here, get this board's input, and perhaps at the end of the day, get another letter back to the village board to inform them further with respect to the special permit that we're seeking.
Okay, so you're seeking another comment or comments?
Yes.
Based on, I guess, whatever comes out of a
Right.
discussion or investigation with Bonnie Franson, our planner. So, and again, the board may do that, the board may not do that, but here's where we are. So that's why you're here. I just wanted to get that clear for the record.
Right.
So you're here seeking another
And
or further.
Frankly, if the board felt it was appropriate, and if you felt it was appropriate, I would love to get a site plan approval subject to the special permit, but we can discuss that another time.
I don't think it's appropriate, if you're asking.
Yep, okay. Can't blame me.
You try. So, I don't know if you want to go through each one collectively, and then have Ms. Franson address them, or,
I think we should. Some of them are pretty easy, I think. Some of them will require more of a conversation. And I don't have a printout of Ms. Franson's letter from today. I do have it on my computer here.
you have a copy you can give them just a minute ago.
And some of them, frankly, we're going to...
Want to use my copy? Do you have one? I got
You have
one.
a copy, just to make it easier.
I can...
Just to make
copy?
it easier for everybody instead of...
Yeah, because that way I can make some notes. And there are a couple of these that I'll have to defer until Mr. Gdansky gets here, which should be momentarily. Frankly, you were very fast on your agenda, much faster than we anticipated. Thank you. Okay, item number one is with respect to the GML review. Frankly, we don't understand what the issue is with respect to the GML review that was previously done. There was a GML review that was sent to the ZBA. The ZBA acted pursuant to that GML review. The GML review did indicate that it needed referrals to outside agencies. Those referrals are generally done by the municipality. And so that's why, from our perspective, they're outstanding. Mr. Chairman, I think it would be a lot easier if we were able to have a back and forth with Ms. Franson on question by question.
Did you want to respond, Ms. Franson?
Yeah, I can.
Yeah.
Sure.
I didn't know how you want to proceed, if you want to go through them all, or...
No, because there's a lot of material here, Bonnie.
It's fine. So my point about one, and to some extent at this point, it is somewhat moot, was that each of the individual boards received a GML review. The ZBA received one, the planning board received one, and I believe the village board has received its... I thought they did, but the point was that the GML specifically stated, and because you're not kind of one board, you're three boards responsible for your own actions, that the referrals that were required by the GML for the ZBA in terms of getting it out to DOT, the Thruway Authority, Rockland County Department of Health, et cetera, that should have been done before the ZBA made its decision, and it wasn't. That was the point I was making. Other than that, so for this action, or for the village board's action, before they take action, if the county said you need to refer it off to these boards, I'm saying we have to do it now. Whoever the next board is, whatever their GML referral states, if it requires, look for permits, look for approvals, unless you override that, it has to happen now. Whichever board's going to act first, and that was the point. And that didn't happen, unfortunately, with the ZBA action, but the ZBA action happened already.
So does it need to go back to the ZBA? Is that what you're saying?
No, you can address.
No, I can't comment on that.
What's your
The
take,
action was
what's your
taken,
position?
so I
If you
just
could-
want to make sure that it happens for the next board.
Right. If you could speak into the microphone, I would just make sure.
Sure. It's not unusual, in fact, it's the norm for there to be a lot of spillover when you have, on the GMLs, when you have multiple boards reviewing. Here we have three different boards reviewing the process, and you're going to get a lot of repetition.
from what's said to from what the GML says for the ZBA, what it says for the planning board, what it says for the village board. And that happens frequently. And generally, the practice has been, and I've been doing this for a long time, okay, the practice has been that if the ZBA goes first and they get a comment like, you need to get a review from DOT, okay, it's the type of thing that needs to happen at some point before the planning board acts on the site plan, because those issues are almost always DOT issues. And in fact, what we had here, the variances that we sought here had absolutely nothing to do with DOT. That wouldn't affect the DOT one way or another. It was the number of parking spaces, it was the width, the lot width, and I believe it was the front yard. Okay, DOT couldn't care less about that, and anything that DOT says would not have an impact on that. We concede that we need to get a DOT review before either the special permit or the site plan approval, whichever comes first. We have no problem with that. So that's what our issue was with respect to that comment.
Right, and one thing I had mentioned was, the ZBA has acted, there's certain, legal consequences, if you will, that has happened, they voted. So in terms of going back again, if the state or the county, or if the county says, well, we're not going to give a permit because, this action wasn't overridden or something didn't happen, that's an issue that the applicant will have to deal with the county. But I think, in terms of the ZBA, that's happened, it's been voted upon, and I'm not sure exactly what the issues were or what was supposed to be sent or what wasn't sent. But what may have happened is
sure.
Because it was originally at Village Board, then it went to Planning Board, then it went to ZBA. The ZBA may have said, well, again, I wasn't there that evening, but they may have said, well, it's already been, the county already has it, the state already has it, et cetera. So that could be that issue. But I think...
Yeah, I would just, I have a lot of experience in various communities throughout the Hudson Valley. I would say what was unusual is the fact that the county had so many comments for the variance part of this. And I think that's where part of the issue lies. But the reality was they were the first in, they were making the first decision. The county threw all these comments at the ZBA, and it's just my position that the way it normally works with my communities, it would be addressed by that first board making it and not deferred. But again, the decision has been made, here we are, and that was my point.
Okay.
And so now, again, with the next board, let's just make sure that the referrals, et cetera, happen, which actually, I believe, we took care of.
Okay.
Right, so that's taken care of.
I haven't gotten anything back from DOT yet, but...
We haven't either.
Okay. Item number 2 has been resolved. You've gotten the new site plan? Okay.
Yes, and we reviewed it.
Good. Okay. Mr. Gdansky is here. Okay. We had a very efficient board this evening. So let me give him a minute or so to just get settled, because item number 3 is really something that Mr. Gdansky should respond to.
And I would say that item number 3 in the concept of storage versus parking is probably at the heart of this whole review and discussion.
Can you explain for the board what your comment number 3 is? That might be, no, I'm asking Ms. Franson, why don't you explain to the board what your comment is about and what?
So, and this is in part also based on my discussions with the assistant building inspector. The expectation is that when you have an automotive repair establishment, the parking standards say that you're supposed to provide 4 parking spaces per bay. Those 4 parking spaces are intended to address the vehicles that are being repaired, employees, if someone's dropping off their car, and there were to be 12 parking spaces for the 3 bays that are proposed. We acknowledge that this applicant went to the Zoning Board of Appeals and received a variance to allow one parking space, which is the handicap parking space, and therefore no other spaces were required for that new 3-bay facility. What is happening, though, is ultimately you're approving a site plan, and the site plan is supposed to show where all the storage is going to be for the vehicles, and, you know, how many, what's the capacity of that lot. Now, they did get the variance for the handicap, or sorry, for the parking spaces except for the handicap space. So in theory, the only parking that becomes available for the facility are the ones that exist at 16 Wayne Avenue. In the back and forth, there's been this discussion about we can park 3 rows of vehicles within the lot to gain that capacity. To do that and to adhere to the site plan, something is not being shown. There are parking spaces up against the 16 Wayne building. There's a row of parking spaces that are on the 16 Wayne site. And then there's nothing shown on 14 Wayne. And that is because it's a maneuvering area and parking spaces are not shown because they explicitly got their variances. So what I think is happening is essentially the applicant is saying we can store them because if you go by the site now and based on my photos, they're parked whichever way to store that many vehicles in. They're stored in the maneuvering aisles, they're stored, you know, cheek to jowl. So, but that's not what the plan shows. And so there's nothing in the law that talks about storage. The expectation was that you're going to park your vehicles that are being repaired in parking spaces. And so we're not seeing, from our perspective, what we need to see to demonstrate that there's sufficient space for the parking. They're arguing they can do the storage, but then there's no map showing that this is the case. And then the question becomes, does that even comply with the zoning and/or with the 16 Wayne approved plan? That's where we're going here. I think to me that's the fundamental issue. And I don't know that the board is going to, you know, be able to solve this. It's a question of what did the zoning intend, and, you know, having parking spaces versus storage, and then what's shown on the plan.
And it's one of the issues that as you're speaking, it occurred to me, is one of the issues that the site plan does not have or show site plan for 16 also? Is that, or it does? Okay, well, hold on. Yeah, I'm just asking, Bonnie. Yeah, you'll address it, Paul. Yeah.
So it does show it. Note that it isn't actually what was previously approved.
Okay.
It varies from what was approved. I don't know that that's substantial, but it does.
Well, and I'm sorry to cut you off, but I guess the issue is, and this is a question for the applicant, is, you know, you're applying for the special permit. When you go for site plan approval, is it going to be for both 14 and 16? I don't think you're eliminating a lot line, right? So, okay. So that would, I guess that might be a question or something for you to address, applicant, as part of what Bonnie said. That's
We are not eliminating the lot line because the 2 lots are under different ownerships. So the site plan application is strictly for 14. This exchange proves why we needed to have this conversation, because I finally have an understanding of what Ms. Franson is concerned with. Okay, with that, I want to just turn it over to Mr. Gdansky.
Yeah, well, wait, Paul, you got to speak on the microphone so we can hear.
So based on her comment, I moved the handicap spots into the hill, so now there's a retaining wall that surrounds the parking and the hatched area for the handicap spot. Additionally, I mean, there's the ability to store cars within the garage, so that's the idea. My client's planning on storing the cars he's working on in the garage. So that's basically it in a nutshell.
Right, and let's understand that there's a difference between the required number of parking spaces, which for this application is 1, which we are providing, and the fact that he does have to store vehicles there. I mean, this is no different than any of the other repair shops that are up and down Wayne Avenue, right next door across the street. They currently store vehicles, not necessarily within regular parking spaces as may be defined by the zoning code, but they do store those vehicles there. If they don't, they can't operate their businesses. It's very, very simple, and I don't think anybody has any issue understanding that. So that's where we had kind of I think the disconnect that I was talking about. We've got 3 bays that we're proposing. We can store three vehicles in there, even though the building inspector, wrongly in my opinion, but even though the building inspector doesn't count those as parking spaces, we don't need to count them as parking spaces. We only need to count 1 parking space, which is being provided. We have discussed the way that vehicles are currently stored on both 14 and 16, so that the board has an understanding that, yeah, there's enough room to put these cars there. They are in neat rows. They're tight together. There's no question about that. Okay, but they're also not being operated by outsiders, by customers. They are being operated solely by the workers who are there, who are very used to dealing with these tight rows. And that's the reason why we've been showing all of these other vehicles as they're stored.
So, again, it's been represented that there can be 3 rows of storage, and we're fundamentally at the question of storage. It comes down to storage versus parking spaces. There are establishments, the longer term establishments, the larger establishments, they have parking spaces where they store their vehicles that are being worked on. I don't know every single business there. I will also say there's other small establishments that have very little area and they're stuffing the cars in them, storing them. It's a mess. They're being parked on the sidewalk, affecting the village's, infrastructure. It becomes, with all the maneuvering that has to happen because there aren't drive aisles and you have to pull them out and you have to back them up, it's a problem. And so we're indicating to the planning board and to the village board, we don't see anywhere in the code that it talked about storage. In speaking with the assistant building inspector, the expectation was that if you are parking vehicles there, it's going to be in a space, and what the applicant is expressing is that they can store them however to be able to fill up the lot to have that capacity within drive aisles, etc. I don't think that is intended by the law, but that's not something that I think we can resolve. I think that's almost an interpretation.
Okay.
So, because it's a difference between having a parking space and having storage. Are some of the businesses doing it? Yes. Or is it legal? That's not for me to answer.
Okay, so I think this is one of those things that may not be resolved tonight, and the applicant, if you want to address it, you certainly can address it. It may have to be addressed by the village board, it may be a legal interpretation, but I think at least it's brought to a head in terms of
Right.
where we are.
We can prepare a drawing that will reflect what's currently going on. Okay, and what's been going on that site for years. I do want to point out, by the way, that there may be vehicles parked on the sidewalk from other repair shops. There are no vehicles parked on the sidewalk with respect to this.
Yeah, I don't think
shop.
that's what she said.
And I want to make that clear because that allegation was thrown out at the village board. Okay, and I don't want it perpetuated.
No, well, I just want it clear that's not what Ms. Franson said.
I understand
about
that, and I'm just clarifying. So we can prepare a drawing that will reflect where the cars are.
Okay, so why don't we move on to a couple of others?
Yeah.
Before, 'cause that's a big one. Sorry.
That is the bulk of a lot of the comments, but I do want to then just note that with this revision to the plan, it's placing the handicap parking space into what is rock. I have a photo of what is there, and so we just need to know, 10-foot high retaining walls, what is that? How is it engineered? I don't know if it's just cutting into the rock. If it's going to be removed, how is it going to be removed? Because we are not far from the throughway right away, and from the throughway actual, the lanes that are used. Would like to see a source for the handicap space detail. There's some questions that we have about the layout, and we want to see how an individual who's in the handicap parking space is going to exit. Because if they have to park head in and they have to back out, they can't maneuver into.
Yeah, I showed the maneuvering on there.
So I'm talking about the handicap parking space.
Yeah.
If you're parked here.
I don't want to be a pain in the neck, but
You got to talk into the mic, though, if you wouldn't mind just dragging it over.
So the map is not showing specifically the handicap parking space maneuver. Again, it's a handicapped individual who is having to maneuver. You can't swing it to the I guess that's to the right, because the 16 Wayne Ave parking is supposed to be there. And then to park it around the other side, it's not shown in terms of whether they have sufficient space to maneuver in front of the bays, but that's something for them to address.
We can show that. We can show all that.
And so I think they just need additional information to provide for the relocated handicap parking space. As I said, especially because it's into rock, sheer rock, next to the thruway.
As far as the details of the wall and the rock, we'll provide that, prior to getting a, final approval. I don't want to spend my client's money if there's any, non-approval of such.
I'm going to say 5, there was just an issue with the scale on it. We didn't receive the correction as a resubmission. That was minor. 6 was addressed. Again, a lot of the comments have to do with this whole concept of the 3 rows of vehicle parking, storage versus in parking spaces. There was a question about whether 16 Wayne Ave is meeting its site plan, and the applicant had asked the board to refer it to the code enforcement officer. I don't know if that happened. So that's.
yeah, what I was thinking with respect to that, and I'll leave it to the applicant, I know you're showing 16 on there. Is there a way you can maybe get a copy of the existing site plan and make it part of your submission?
We actually did.
Okay.
Unfortunately,
Just make sure you're speaking into it.
unfortunately, the village's records from, as we go back, are incomplete. At one point, there was a flood, records were lost. We submitted a plan that we believe to be the approved plan. Unfortunately, it is not signed. And that was done at the very, very beginning of this application.
Oh, it does, I'm sorry.
And that's represented on here, too.
Ms. Francis' comments do say that it has been submitted.
Right, we have, there is
Okay.
a copy of the plan. The plan doesn't match what's shown there. So the
In terms of
question is whether.
existing conditions.
Correct. So is there do they need to do things 16 Wayne separate and apart from 14 Wayne? That just came up through our analyses.
That is something that's come up.
Yeah.
Again, we could talk offline on that, but.
We've been asking for the code enforcement and
Well, it's-
Branson has been asking for code enforcement to weigh in on this.
But I mean, if you want.
For a year and a half now.
But why do you need code enforcement to weigh in? You have a plan, you have existing condition that you're showing. I mean, do you want them to say, yeah, he's in violation? I mean, why?
Ms. Branson raised that, so.
No, I'm saying, why, I mean, I don't know,
I think it should just
right, either, why don't,
change it or
right.
get the amendment.
Well, that was
That was the point.
That's what I had said earlier. If existing conditions are different and you can amend that site plan or get a new, maybe that's part of it. Might not, you don't have to decide tonight, but as I'm sitting here thinking, maybe that's something that when you go to the village board, you say, look, when it comes back, or even this board, we'll seek an amendment to the site plan for 16, because they are related, right?
I mean, understand that the applicant doesn't want to open up 16 Wayne, but part of the whole discussion had to do with if it doesn't comply now and you need an amendment, then why not look at the whole site holistically and make sure that everything works, and maybe, if possible, try and limit the amount of maneuvering in and out of 2 spaces where often you have to back out onto a state highway. So that was the whole point with regard to 16 Wayne and trying.
Right.
So I'll leave it at that.
Yeah. Okay, so it sounds like they have, Ira, you know the issue. and-
Yeah.
We understand.
Okay.
8, again, we've talked about the lot merger. Again, it has to do with 16 Wayne and the interaction with 14. And we've talked about the storage. That's the same. 9 variances, we don't have additional comments. I will note, though, that Adam indicated, and you had responded about the landscaping. And I don't know if there was a variance for the landscaping. I just don't recall. It's a special permit requirement about landscaping along all the property lines. And since it's not being merged, then it has to be along all the property lines because it's part of the special permit.
No, it was up against, I believe the standard is against a residential district. No?
There's
There's
2
two?
places.
There's 2 places?
And one is in the automotive repair special permit itself.
Okay, I'll take a look at that.
Yeah.
I don't know if it was this project or another one, but I seem to remember it coming up, and now that I think about it, it might have been a different project. Right? That might have been Joanne, that might have been 23 or 20 Wayne.
23?
Yeah. Anyway,
So,
all right, but that's another issue that they're aware
yeah,
of.
that we
Okay.
have to address. Number 10 is we have to get something back from DOT. 11 has to do with DOT and getting a response back from them. 12 is regarding that landscape buffer. And again, there's 2 sections, so we just need to make sure we're looking at the special permit requirement. Landscaping, DOT, again, site distance, I think that DOT can weigh in on that. 14, no change. So 15.
Well, let's go back to 14 for a
Okay,
second.
okay.
Okay.
No. You wanted the planning board to review the other sites.
Yeah, we actually, and at the time that I wrote this, I had said that, you should be looking at, you can look at this, your own knowledge of the village, your ability to go out and do a site visit, not only for us, but you can also stand on the sidewalk and look at the other sites. We actually did submit a FOIL request to the village for site plans for the other sites. And unfortunately, ran into the same problem that we ran into with getting 16. There's very, very little that's out there. Although I will note that one of the documents was minutes of the planning board meeting for a preliminary approval for 23 Wayne Avenue, which is the 20 Wayne Avenue, which is the parking lot which is just next door to the 16 Wayne Avenue, and is being used by the repair facility across the street. Just so happened I was on the planning board at the time and made the motion for approval. So that was, a little tidbit many, many years ago. But yeah, it's a matter of, again, this is not an unusual situation in Suffern where you have vehicles maneuvering along Route 202, because this was an issue that Ms. Franson had brought up, and frankly was brought up also by the mayor at the village board, of taking vehicles and going onto Wayne Avenue and back into another lot, and it happens all the time, and it's been happening for years and years and years and years, and somehow it doesn't seem to cause a problem.
So our only reaction was just that if you go out and look at the sites, we don't actually know which ones are operating in accordance with an approved plan. So
I'm sorry to cut you off, but this sounds more like because Mr. Emanuel said something we're trying to,
Well, I think
see if it's true, but,
Right,
doesn't matter.
He had a list, right, he had a listing of businesses and how they were operating,
Right.
and from my perspective, we don't even know if they're operating
Yeah.
in accordance with the plan, so I don't
Yeah.
even know
Yeah.
how helpful it will be.
So we'll put it back on Mr. Emanuel to address that, if appropriate.
Let's go on to number 16.
Six,
Or are we up to 15?
I think we're up to 15.
15, yeah.
I think, again, this is just this storage versus the functioning
Right,
of
so
the
I think
plan
we're-
and
I
the
think we're-
storage
yeah.
and showing how it actually will operate.
Yep.
It's the same issue.
Okay, and 16 is a similar similar.
Yep, yes.
Right, these are all related,
Are
yeah.
all the same. So, then we get into the actual site plan comments, so net lot area addressed previously. The only thing I'll say is, I don't recall in the plan, you're now going into a steep slope area, and whether the villages say that you cannot. So, we just have to see how that net lot area provision is worded. Number 2, the site plan was revised, and this was just commenting on the handicap parking space again. So, number 3, I don't think there was anything there.
You had asked for building elevations.
And you provided them.
Yes.
Yep, so we didn't have an issue there.
Okay.
We only just had one issue where one of the plans just had the wrong scale on it, so it needed to be corrected, but it wasn't anything major. Number 4, loading area, again, it's this, how do you use the space? The zoning anticipates that you have a dedicated loading area, but here it's we'll park in a space or we'll park in the aisle, drive aisle, and it's, again, just this whole concept of how these automotive repair establishments operate. Sheet 2 of 5, we talk about the handicap space, and we had our comments that we raised previously. Sheet 3 of 5, with regard to site distance, we anticipate DOT will deal with that. Sheet 5 of 5, we just wanted the source for the handicap parking space detail. That was minor. And then in the special use permit standards decision-making, I'm going to say that the bulk of it has to do with, again, storage, parking, how the site's being used.
But there is one other item that was in here somewhere that we didn't, one other item that was in here somewhere that we did not just address, and that is with respect to the easement between the two sites. And Ms. Franson in her memos seemed to indicate that she needed to see a meets and bounds description or, well, graphically, that the easement be shown graphically between the two sites, and that there should be some internal connection between the two sites. Obviously, if we do that, we're going to lose the ability to place cars wherever that easement is, and the easement does not need to be shown graphically. It's just a it's basically an easement over the entire parcels.
You're calling it a cross easement, basically,
It's
that
a
both can
easement,
cross.
Exactly.
Right,
It's a
so-
cross easement. Unlike the traditional cross easement, which would be across the property line, it does allow the owner of 14 to bring vehicles onto 16 and vice versa. And that's the nature of the easement that we're talking about.
Without getting too technical, it's more in the form of a license, right, when you think about it?
Well,
I'm
yes,
just saying in terms of...
except that it runs with the land, yes.
Yeah.
So we just want to bring up, and again, this gets to capacity. If you essentially, on 14 Wayne, do not have parking spaces, you have the bays, you have the handicap parking spaces, but there's not much room for storage. And they really are storing it across all of this 16 Wayne site. If 16 gets sold, in as much as 14 may say, I'd like to park my vehicles on 16, what if 16 is loaded with his own vehicles that he's repairing? So I think it would be useful to understand what the nature of this cross easement is, because, you know, is there a guarantee that that 14 would have access if 16's at capacity? And I just think it's something to raise and address, and how that would be, you know, otherwise now we've created a lot with no parking and 3-bay garage.
She's right, and that's why in the very first narrative that we submitted, we talked about the fact that there would be a declaration that would be recorded in the Rockland County Clerk's office to take care of exactly that situation. And that would be subject to the approval of the Village Attorney's office.
Right, and I think what Mr. Matthews indicated, so anybody buying that other property, if they were sold separately, you know, would know that that exists. Now, is it, you know, and that the person from 14 could park on 16 and 16 could park on 14, but, you know, we could work out the details on that if it got to it.
It's drafting. It's not particularly complex drafting. You know, we know the issues, we know the eventualities, and we know how to make it enforceable.
Yeah, that's something to be addressed, but, all right, sounds like you have, you know, some work to do if you want to come back.
Right. Understood. And Ms. Franson, I really do appreciate your being here and having this conversation with us. I would ask you one favor, though, okay? This has become unwieldy.
I know. I agree. We need to start afresh.
Yeah.
Yes.
Yeah. So if you wouldn't mind, based upon the conversation that we had now, issue a new memo that just sort of consolidates all of this.
Well,
I mean, this is still part of the record.
yeah, I mean, it seems, I mean, it seems you have enough to at least.
Oh, we're not going to wait.
No, my suggestion would be, frankly, for you to do whatever you got to do based on tonight. You know, this is all recorded, so you can watch it whenever. And then, you know, I think, you know, Ms. Franson's seen what's gone on, and I think it'll get narrowed to what you give, you know, the next time. I think that's probably a better way to go.
Yeah, I can summarize bullet point what the main issues are. I'm still, and as much as I know you're talking about declarations, et cetera, I don't know if that's more like a buyer beware. And you're buying, so that's a question, I don't know if it is. So
we can have a conversation.
You as a planning board are supposed to create lots and configurations that work for properties. And so it's just useful to understand what the language is going to be to address this concern. That's all.
I can prepare something that will, and I think I already did, but I can perhaps provide a little more detail as to how it would work without actually drafting the document.
Yeah, some narrative.
Yeah, understood.
So I'm curious, are you finished going through the document back and forth, both parties? Okay.
Yeah.
So I want to ask if members of the board have any questions or comments or anything else?
I got one question. Is somebody going to go through the New York State Department of Transportation and have them do the sight lines and stuff like that? Because it said the applicant should be the one, you know, whatever.
Well, so there was a little back and forth in the memos only because if the applicant requires a permit, it really is their responsibility to be communicating with DOT. But to start, we're reaching out to DOT to ask them, do you need a permit? And again, this is also tied to the county review and wanting to reach out to certain agencies. If they don't respond, we can't control that, but the one agency that I think we would all like to have some kind of response from is DOT, because 202 is their road. And if they have no issues, you know, great. If they have issues, then we need to address them.
Oh, no news is good news.
Yeah, and let me just state, the reason why we said that it was up to the village to do it was because it was part of the GML review. And my experience is that when you're dealing with GML review materials, if it comes from the applicant, the agencies don't want to hear from you. Okay, at some point, yes, Ms. Franson's absolutely correct. If DOT comes back and says you need a permit, okay, then it's on us to reach out to DOT and make the permit application, not the village.
Anybody else have any comments or questions, or before I ask mine?
Okay. I would like the ability,
He has-
Mr. Chairman.
The chairman wants us.
Oh, I'm sorry.
Yeah, so we've got 3 boards and building inspectors and who else isn't. I think we need to get together and make sure we're doing things procedurally properly as well. Because one thing and I've read through this and the other ones and the other ones and everything else. I just want to make sure we're doing it right. You know, that procedurally, I mean, you know, the zoning board of appeals approved something, but things may have changed and maybe, you know, so I think we need to have a conversation with Ms. Franson. And, you know, I don't know if we can directly talk to the ZBA or whatever we have to do to make sure, you know, maybe the attorneys talk, just to make sure that we're on the same page procedurally, because the one thing that's clear is that we're not clear. So let's, you know, do that and go from there. Are you in agreement with that?
Yeah, I mean, that's why we, you know, laid it out at the beginning. This is, you know, here for its purpose. And, you know, what Mr. Emanuel's asking, again, the board may make a comment to the village board, the board may not make a comment to the village board, but that's...
Right. As I said at the outset, it was very clear that during the village board's consideration of the special permit, there were issues with respect to how the site plan was configured. That's why we're coming back to this board to get direction with respect to that, to move that forward so that hopefully the village board will be more comfortable when we return to them on the special permit. We're not asking you to usurp the village board at all. We're not looking to cut corners. We're not looking to do anything that's incorrect procedurally.
No, I don't think, you know, I just want to make sure, because I don't think anybody's like, wait, this was supposed to happen, but this happened and this superseded that. I just want to get clear on our end, and then we'll communicate it to you and your client.
It got complicated.
Go from there.
It got complicated.
Yeah, I mean, and just so we're clear, I think there's nothing for this board to do. There's nothing for Ms. Franson to do right now. It's in the applicant's hands, and if they have something to submit, they can submit it, and we'll submit it to Ms. Franson.
I would like the ability to have offline conversations with Ms. Franson so that we can perhaps work out these details before we come back to this board. And before we come back, you know.
Do you want to address that?
Yeah, listen, that had come up, and I know we had discussed it. I think the concern has been that the public hearing, you know, it's kind of been all over the place with, you know, ZBA and planning and village boards. So, you know, at this point, I think it's best to do as we did tonight.
All right. In that case,
make a submission, and if appropriate to have you come back, we'll have you come back.
all right. And we'd like Ms. Franson. All right, fine. We will deal with it that way. Okay. Thank you.
All right, thank you.
Thank you.
Okay. All right, next, Orange and Rockland Utilities has been removed. So, any miscellaneous business? Any old business? Any new business? Okay, do we have a motion to schedule the date for the April meeting to April 22nd, 2026 at 7 p.m.?
I'll make that motion.
Mr. Halper, do we have a second?
Second.
Mr. Murphy, all in favor say aye. Aye. Motion carries. We have a motion to adjourn.
I'll make that motion.
Mr. Halper, do we have a second?
I'll second it.
Mr. Van Sickle, all in favor say aye.
Aye.
Motion carries. Meeting is adjourned. Thank you, everybody.